What's up, guys? This is Manoj Poptani. I welcome you all on behalf of the Edupedia world. So, it's been a while that I interacted with you with one of the most relevant topics as far as the CA final is concerned. So, I thought maybe I should bring something good and exciting for you guys to hear about. Okay, the nation and the people are running behind money, all the way. It's everything related to money. So, people are running like anything just because of one thing, and which is actually taking the inner peace, the satisfaction, and each and everything of this world, and that is money. So I thought maybe I should tell you something about the Prevention of Money Laundering Act in that particular case. So maybe that's going to bring in your interest. Here also you'll get money and you'll get to know about something related to money laundering. So with this presentation, I'll mark the beginning of a most relevant topic of CA final, Corporate and Allied Laws, that is the Prevention of Money Laundering Act 2002. What all are the provisions, what all are the definitions, what all will be the penalty which will be paid if in case a person gets involved in any of the act relating to money laundering. So let's mark the beginning with the complete enthusiasm with each one of you. So fasten up your seatbelts, we are about to take off. But do ensure one thing, once I'll let you understand these topics, do not forget to revise, because that's an extremely crucial thing. It needs to be done accordingly. Perfect. I'll mark the beginning with the first topic of the day, and that will be about the objectives. Obviously, guys, first thing always comes first, like always. So, why this act was made? The Prevention of Money Laundering Act. Why? Each and every act and law which comes to our nation or maybe another nation, it's because of some necessity. Okay. Something must have happened in the past which resulted in some of the bringing or incorporating of any of the act into the system. Why government or the people around tend to look into those things, that some kind of mishap has already happened and they don't want the same thing to happen in future. So that's why they bring into the system an act. So that's the thing which happens with the objective of any of the act you see. So why this act was involved? Number one, their objective was to prevent money laundering. Money laundering basically means you have earned some amount of money and you are concealing your resource. You are not disclosing it to the government and you are trying to convert that money of black into white via a few means. And that particular thing is just not legitimate. So that's something about the money laundering. So the government basically wants that this malpractice is completely curbed. So they want the prevention of money laundering in this particular case. Why? Because this money is just not the legitimate one. It has been earned via some kind of concealment. So they want this complete practice of money laundering to get prevented all the way from the system. That is their number one objective. Number two, that they need to combat channelizing of money into illegal activities and economic crimes. Do you even have an idea why our Prime Minister, Mr. Narendra Modi, why he took an initiative for demonetization? Many people usually say, okay sir, there have been many of the instances wherein corruption was noted into the system and he wanted to remove that corruption from the system. But you'll be shocked to know and surprised to know the fact that his main agenda was not about corruption. That was one of the main agendas, but not the primary one. So the primary one was to basically keep a track on terrorism activities. Why? Because it came out to be a news that Pakistan and China have started printing fake currency notes. Okay. And they were like exactly similar to the kind of legitimate notes. And that funds started coming into India. Okay. So in order to ensure peace and harmony, that was the first thing that he took into his account. Okay. And that was the demonetization drive. With that, all the machines, all the basic plates, the plates with which the currency will come into the system, that can be curbed at the same point of time. So this objective of the act will be to combat channelizing of money into all the illegal activities and economic crimes. Number three, to provide for confiscation of the property which has been derived from and involved in money laundering. Let's suppose you earned money from somewhere else. Okay, you concealed the fact from the government because that money you earned was just not the legitimate one, and you build up any of the property from that money. Don't you think so that the government is smart enough to confiscate that property? Obviously they will do once they'll get to know about the act. So This particular act also provides for confiscation of the property which is derived from or involved in money laundering. And the fourth one is to provide for matters which are connected therewith and incidental thereto. About three main topics. So this is about the objective of the act. This also came in a form of question in one of the CA final examination for CA final May 2013. Moving on to the definitions. The number one definition, we're talking about money laundering over here. So in any of the case, I need to tell you something about the definition of money laundering. First of all, this will be covered under section 2, subsection 1, clause P and section 3. This question was asked in CA final examination for May 2012 as well. So money laundering has a meaning which is assigned to it in section 3. Whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved. Now, I'll tell you about all these four activities with the help of example so that I can brief you up and you will get the complete clarity. Number one, there is a person. He hasn't entered or involved directly or indirectly in money laundering. However, he attempted to indulge. Ram came to Sham and asked Sham, I have got some money. I don't want to clear out with the kind of concealment issues, and since this money is not legitimate, are you going to offer your help in me settling this amount? Sham readily agreed. And finally, maybe after the way, he just backs out from the entire thing and didn't receive any of the money. So he tried and attempted to indulge in that particular act, directly or indirectly. So that will be covered in criteria 1. Number 2, Sham again is the person who knowingly assisted Ram. He was the person who gave a nod to him that, okay, I'll be there to help you out. Again, third case would be that Sham became the party of that, knowingly that this money is just not the legitimate one, and this money is going to be involved in the in those money which will be classified as the concealment done cases. So knowingly became a party to it or is actually involved. Finally, Sham readily agreed, okay, dude, I'm helping you out, so why don't you just pay me 20% of that? So he actually got involved in that. So in any of the four of these criteria, if you fall in any of the process or activity which is connected with the proceeds of the crime and you projected the same as an untainted property. Okay. So by untainted property, I simply mean that there hasn't been any kind of marks of that property. So this is an absolutely like clear property. So there have been no cases of taints on it. There have been no cases of marks on that. So you projected it to be a very genuine and a very clear kind of property. Then in that case, you shall be guilty of an offense of money laundering. So money laundering has a meaning assigned to it in section 3. I hope you guys got the complete clarity with the kind of example that I provided to you. Perfect, guys. Let's move towards the second definition, and that will be of the proceeds of crime. Here it's written in money laundering that any person who is connected with any of the process or activity connected with the proceeds of crime. Now you'll get to know what does proceeds of crime actually mean. The same is covered under section 2, subsection 1, clause U. So proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or value of any such property. Okay. So proceeds of crime is basically like simply the kind of money that you'll be receiving in terms of any property or cash directly or indirectly by any of the person who has indulged himself in any of the criminal activity relating to a scheduled offense. So that is something which has been like provided on the list and the websites. So what does scheduled offense actually mean? So they will cover many of the offenses, and those will be considered as scheduled offense and the value of such property. So this will be covered under proceeds of crime. So this is something which will relate towards money laundering as well. Now let's move towards another definition, that is scheduled offense. Now since I was about to tell you about this particular stuff, like what does scheduled offense will include? So this is something which will be relating towards scheduled offense. This will be covered under section 2, subsection 1 and subclause Y. So this question was asked in CA final examination for May 2012 itself. The scheduled offenses means the offenses specified under part A of the schedule. So there is a schedule which has been like provided by the government itself. So all the kind of offenses which will be like specified under part A of that schedule or the offences which have been specified under Part B of the schedule. If in case the total value involved in such offences is 30 lakhs or more, or the offences which are specified under Part C of the schedule, then in that case, this particular offence will be considered as scheduled offence. Number 1, it can be covered under Part A. Number 2, it can be covered under Part C. Okay. And number 3, it can be covered under Part B. However, if in case the same is being covered under Part B and the total value involved is less than 30 lakhs, then in that case, that won't be considered under scheduled offence. But if in case the same is being covered under Part B and the total value involved in such offence is more than 30 lakhs, then it will be considered under scheduled offence. Whereas if I'll talk about Part A and Part B, both these things are just not having any monetary amount involved in them. So in any of the case, if you get caught any of the offences which are specified in Part B, Part A and Part C, then in that case that will be considered under scheduled offence itself. And I hope you guys got the complete clarity with respect to the same. Let's move towards the main chapter now. Okay, so what does money laundering and what do we have to understand with respect to money laundering now? Money laundering with siphoning of funds. This question was asked in CA final examination for May 2013. Many people usually get confused with this thing. Okay, they ask me, sir, does money laundering actually the similar thing with respect to the siphoning of funds? Yes, it is similar, but that's not the same. Okay, there is a difference between them. Money laundering is something else. Siphoning of funds is absolutely something else. Okay, so mere earning of money or income or deriving any property by committing a crime, this does not amount to a money laundering. Okay, though it may amount to siphoning of funds. You try to siphon the funds. Okay, but this won't be categorized under the category of money laundering. Okay, deriving or obtaining any property by committing a crime which amounts to scheduled offense and then projecting such property as untainted property will amount to money laundering. So you try to embezzle something, you did a crime. All those crimes will be covered under the category of siphoning of funds. However, they might not end up being classified as money laundering. But if in case you derive any of the property by committing a crime which amounts to scheduled offense, I'm talking about this again and again because this is something relevant for you. So all those properties which you will be like getting or deriving or obtaining by committing a crime, only the ones which have been like amounting to scheduled offense, and then projecting the same property as untainted property, as a genuine one, as a clear one, then only it will amount to money laundering. Otherwise, if the same crime doesn't amount to scheduled offense, then it's merely the siphoning of funds. That won't be classified under money laundering. Is that clear, guys? Let's move towards the next topic, and that will be the punishment. So if in case you get charged with offense relating to money laundering, the same is covered under section 4. This question was again asked in a previous attempt, that was CA final examination for May 2012. There will be two types of imprisonment. Okay, imprisonment up to 7 years. When you'll get particularly that imprisonment, you'll have to understand that. So a rigorous imprisonment will include, number 1, minimum 3 years and maximum 7 years. So this will be the time frame of imprisonment if in case you're charged guilty of the offense of money laundering. So minimum 3 years, maximum 7, and a fine of maximum rupees 5 lakh. So this is one case, but the same imprisonment will get increased up to 10 years if in case you are involved with any of the proceeds of the crime which are involved in money laundering relating to any of the offense under the Narcotics, Drugs and Psychotropic Substances Act 1985. Then in that case, this imprisonment will be minimum 3 years and a maximum will be up to 10 years in that case. The fine will remain same, that will be maximum of rupees 5 lakh. Now, I'll make you understand why this thing has been done. Because there's a fact behind it. The complete mafia and the complete money laundering activities is basically going on a few of the things. And one of the major things is involvement of drugs in the nation. So many people are consuming drugs, and this is something, the kind of revenues which the company or that association of persons who are actually earning through drugs is just not the legitimate one. They don't disclose the kind of money. How can they? I mean, that's a criminal activity in our nation, and you are getting the money proceeds from that. So this is something which the government is deeply concerned about. They want to curb it completely. However, they are like resorting to many of the aspects, but still they haven't got a complete hits toward it. So the imprisonment will increase if in case the person will also be involved in Narcotic Drugs and Psychotropic Substances Act along with the money laundering. So that will be the maximum imprisonment up to 10 years in that case. So that's the difference between the imprisonment in a normal money laundering case and with if the same is being concerned with the money laundering case along with the Narcotic Drug and Psychotropic Substance Act case as well. I hope you guys got the complete clarity with respect to the kind of punishment that the person will be charged with if in case he or she finds to be guilty with respect to money laundering case. Let's move towards the next topic, and that will be banking companies, financial institutions and intermediaries to maintain records. This will be contained in section 12. This question was asked thrice, one of the major questions. See final examination for November 2008, 11 and 13. So guys, in order to ensure that in our nation, in India, the companies which are working in the banking sector, the financial institutions and intermediaries, the government wants them to maintain their records. If in case something occurs later on with respect to any of the cases with money laundering, then in that case the banking company should be able to prove that this was a transaction which was done so many years before and which was just not the legitimate one. So they need to maintain the records for so many years. So every banking company or the financial institution or the intermediary shall, number one, they'll maintain a record of all the transactions, the nature and value of which may be prescribed, whether such transactions comprise of a single transaction or a series of transactions integrally connected to each other, and where such series of transactions takes place within 1 month. So they need to maintain all these records. Number two, the banking company, financial institution and intermediary, they shall furnish the information of those transactions to the director of their company within such period as may be prescribed. That's their requirement. They need to duly provide and furnish the complete information of those transactions to the director. And number three, they will furnish something about verification. They will verify and maintain the records of identity of all their clients in such manner as may be prescribed by the government by notification. That is something which is required to be done. So majorly they need to maintain a record of all the transactions, its nature and value. They need to furnish the information of transactions to the director, and they need to verify and maintain the records of the identity of all the clients. So that is their duty, be covered under section 12 subsection 1. Moving on to the second thing, that is furnishing the information where transactions are below the prescribed value are suspicious. This is a proviso to section 12 subsection 1. So where the principal officer of the banking company or financial institution or intermediary has a reason to believe that a single transaction or a series of transactions which are integrally connected to each other have been of the value which is below the prescribed value, so as to defeat the provisions of this section, then in that case, because of the fact that the person involved is suspicious about the thing, so he need to ensure that such officer shall furnish the information in respect of those transactions to the director within the prescribed time. Guys, something is happening and that person is suspicious that the transaction is extremely lower than the prescribed value, then why is it happening? So in that case, he shall furnish the information to the director within that prescribed time. Number 3, about the period of maintenance of records. So that will be 10 years. So the records which are referred in this particular section, they shall be maintained for a period of at least 10 years. Okay, I mean that's the minimum time period. They shall be maintained for a period of 10 years from the date of transactions between the clients and the banking company or financial institution or intermediary as the case may be. That's a simple thing. So you need to keep this in your mind that at least 10 years from the date of transaction or cessation. Let's suppose there was a person who had one of the transactions done and after that he closed the account. So he didn't enter into any of the transactions. So still the bank needs to maintain that record for at least 10 years. So if in case of transaction, if the account is open, then 10 years from that date. And if in case keeping the records I'm talking about, so if the account is closed, still the company needs to ensure that they maintain the records for at least 10 years from that cessation. Perfect guys. I hope you guys got the complete clarity with respect to each and every provision of banking companies, financial institution and intermediaries which are required to maintain the records. The same was covered under section 12 of the Act. I'll be taking care of the remaining portion of this particular chapter, this Act, in my next forthcoming presentation. Till then, I'll be concluding my presentation with the dose of motivation, and that will be hold yourself to a higher standard than anybody else expects out of you. Henry Ward Beecher was the person who mentioned this beautiful quote. So always and always dream big, desire big, and work hard accordingly towards those fulfillment of those bigger dreams. You need to ensure that you need to hold yourself to a very higher standard, okay, than anybody else expects out of you. There could be a person who will be like telling you up, okay, dude, you can just complete your college and get settled with the job. Why job? Why don't you go towards any other professional good courses? Think about CA, think about CFA, think about any other good course. But think about it. So you just need to hold and increase your higher standard, okay? At least your standard of thinking first of all, before you change your standard of living, and just hold yourself to a higher standard than anybody else expects out of you in that case. That is extremely important. You are the person who creates your own self-esteem, and you don't need to forget that. With this, I'll say thank you on behalf of the Edipedia world. Keep interacting with our questions, queries and YouTube comment boxes. I will love to answer each one of your queries and grievances. Stay connected. That will help us in understanding your needs way better.